You think? Okay. Jefferson County Court at Law number 2 is back in session in cause number 329864. Case of style of state of Texas versus Jimmy Lawrence Morton III. Mr. Morton, is that your full name?
Yes, sir.
How you doing, Mr. Morton?
Doing good.
That's good. Mr. Morton, you're here represented by your attorney, Mr. Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
That's good. Now, Mr. Lawrence, what is your announcement in Mr. Martin's case?
Well, we were hoping that you would consider dismissing the case because we do have a motion to dismiss on file with an affidavit of non-prosecution attached, which I have shown to the prosecutor today. I have an email from Julie Maxey saying that Ms. Hubbard, who is the complainant, signed up for the options class but did not show up. However, the information that Mr. Martin got back from his contact person that contacted Ms. Hubbard was to the effect that she did attend the class on October 7th, which is—
We got bond conditions in that case?
The prosecutor does not have that information that she attended the class. And to be honest, I haven't had much contact with Ms. Hubbard, Ayanna Hubbard, and I do not know if she has a certificate or not from that class. So that's the stage that the case is in, but she, way back there, this motion was filed on January 14th of 22. This motion to dismiss that has the affidavit of non-prosecution attached.
Yeah. Now,
which I have a copy of.
Yeah, we have
it. Okay.
yeah, Mr. Ham.
Yes, Your Honor.
What says the state?
Do
Do you need some time?
This is the motion to dismiss, Your Honor.
Okay.
And
I noticed.
I don't know that it's maybe the best idea for defense counsel to be calling victims and complaining witnesses in this case. Additionally, as far as procedure goes regarding the affidavits of non-prosecution and the options classes, the victims will, if they attend the options class, they will receive a certificate.
Okay.
And it would be noted in the log. Additionally, they would, it's much preferred by the state that if we're going to be reviewing affidavits of non-prosecution, they be those that are executed at our offices, not ones created by defense counsel.
Okay.
Thank you.
Okay. Yeah.
And the affidavit of non-prosecution was signed on October 4th of 2021.
Okay.
That's quite a while. That's pretty soon after these charges were brought.
Yeah. Now, Mr. Lawrence, I noticed, I'm looking at the motion. You cite no authorities for your request, no statutes, no codes, no case law. And there's no precedence that you have cited to show that one, a court can dismiss a case without the motion being filed to dismiss by the state or on any other grounds. So at this time, this motion will be denied. We can set this matter for trial. Well, Mr. Martin, you can't talk directly to, you got to talk to your attorney first, and if your attorney wants you to say something that's non-incriminating, you can do that. Now, I would, your attorney made a statement about an indirect contact, and I'm looking at the conditions of bond that says, a standard bond conditions in County Code at Law number 2, and it said, following arrest and accusation in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. And number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Okay? So if you want to talk to your attorney first, we'll give you an opportunity to do that. Okay?
Your Honor, if I may, just for a second, they are still married. And
You can take a look at the bond conditions.
yes, the only way that I can deal with these cases where the wife is wanting to drop the charges is to find an intermediary who will speak to the wife, and that's what we've done in this case.
And Mr. Lawrence, you have a duty. What?
Well, just
Do y'all need to talk?
we probably do need to talk. But I learned long ago in these cases back when Judge Flores was the judge in County Court 2, that to do an affidavit of non-prosecution like I do them without using the prosecutor's office, because it was explained to me by the woman who's over the family violence unit, the woman prosecutor, that they have a quota. They have to get so many convictions of all the cases that are filed.
Now,
No,
let me-
that's not true at all.
Oh, okay,
That is not true at
Mr. Lawrence. Okay. I handed you bond conditions that stated that your client is not to have any contact, any communication directly, and that's what we was talking about. Now, you going on a tangent, talking about you learned from Judge Flores a long time ago, and you could correct me if I'm wrong, but I think it has been the policy of the district attorney's office that individuals who will do a non-prosecution affidavit has to come to their office and execute that non-prosecution affidavit. But that's neither here nor there. Now, what I will do is give you an opportunity. You can talk to your client, and then we can revisit the case. I do know that we have Mr. Ham, who wasn't the original prosecutor on the case. You read a letter, I think, from Ms. Julie Maxey, who is no longer with the district attorney's office. And that is no longer Ms. Maxey's case. It is now Attorney Ham's case, okay? So at this time, we'll just put this matter on hold, give you an opportunity to talk to your client, and you can talk to the prosecutor when he's available too, because as you know, right now, we only have one prosecutor in this court. So, and he's handling all of the cases here.
Yes, Your Honor, in that case, it's like I explained to you, that they are still married. And I think they are considering what's going to be, I think each individually is considering what's going to become of their marriage as this rolls along. But he has not been in contact with her. What I am asking is that that you allow me to contact Ms. Hubbard.
Well, I can't give you any permission. I mean,
Well, I'm his attorney.
no. Okay, you have the right to investigate. I mean, you need to research and see what your rights are as an attorney. I can't, I'm not ordering you to do anything. You need to basically, I mean, you're an attorney, you've been an attorney for a number of years. And so you need to research and see what you can and cannot do. And so we'll just
I'll
leave it at that.
If I could, Your Honor, just.
Your client is
I'm
raising his.
gonna, well, if we're gonna reset the case, then I'll talk to him outside.
That's fine. And what I'm gonna do, should we reset it on the trial docket?
No, Your Honor, please. What?
Well, we'll put it on a pre-trial conference docket.
What I need to,
Or do you just want to keep it on the announcement docket?
just keep it on the announcement docket, if you
Okay.
will, Your Honor. Well, the issue is whether or not I could contact her.
Well, no, right now, we just need to know what docket you want to put it on the pre-trial you want it on the announcement docket? We'll put it on the announcement docket.
Just leave
In
it
the
on.
case, we'll give you, could you give us a reset date?
30 days.
Do you want a standard reset? Do you need 60 days? Or,
Let's go with somewhere past 60 days, sometimes in June, since the weather is better in June. If people, Your Honor, I don't know if you've noticed, but because of the pandemic and the rising gasoline prices, it would be better to schedule it for sunny weather, I think, to be sure everybody can be here. So sometime in
No, let me
first quarter of
just
June. If you
now,
don't
hold
mind.
on, you're saying so that everybody could be here. Now, we're not setting it for trial. You're setting it for an announcement.
Yes.
Now,
yes.
the announcement, as it is today, you can appear by Zoom, by telephone, or in person. So the weather doesn't have anything to do with you appearing by telephone
True.
if you don't have Zoom.
I'd prefer to set it in possibly early June or
Well,
middle
what I'm
of
gonna do,
June.
we'll give you, if we give him 60 days, where will that fall?
It'll be May 27th.
May 27th.
I've got some big cases in May, and I would really like to go for somewhere in
What's,
early to mid-June.
okay, what's the next date after that?
Um,
After the May 27th.
it's, June 6th.
Okay, we'll set it for June 6th, okay?
June 6th, good. And I will get a copy of the reset notice.
Okay,
Your Honor,
let me see, I need to make a note. What? Okay, June 6th. Now, what was your question?
I was trying to explain the woman who was the first head and may still be the head of the family violence unit in the
But-
DA's office explained
Mr.
to me
Okay, if
that
you
to
want to,
get their federal money, they
well,
have to have
Mr.
so many cases.
Your Honor,
Yeah.
if he wants to talk to me about this off the record, I'd be happy to, but
Right.
As far as I know, what he's saying is completely false, and he hasn't named any specific individual anyway.
Right,
I'll think of her name.
That would be great.
okay, y'all can talk to each other. Mr. Lawrence, you can stand on the X and get your reset. Once you get your reset, you'll be free to go. And I think you said you was gonna talk to your client in the hall. Now, Mr. Martin, once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Lawrence, you have a blessed day as well.
Yes, thank you, Your Honor.
Yeah. He's here. And get those, is Cobb's, his client is Karen Johnson. And get those pro se, the 3 pro ses in too. Look like, Karen Johnson got a reset, not a reset, but a felony for May 4th. Oh, he just got up. That was not Cobb, but McIntosh.
Yes, Your Honor.
Okay. Here we go. Okay, court is in session in cause number 330262. Case is style of state of Texas versus Karen Johnson or Alicia. Karen Alicia Johnson. Okay, how you doing, Ms. Johnson? I'm doing fine. Ms. Johnson, you're here in person and you're represented by your attorney, Mr. Bruce Cobb, who is appearing via Zoom. Mr. Cobb, could you take your mic off of mute? Must have some, he might be having some problems. He's on Zoom. Mr. Cobb, could you take your mic off of mute? Okay. Ms. Johnson. Just have a seat in one of the chairs that have the black and yellow tape. And if he comes back on, we'll call you back up. If he is able to unmute it. Roberta Davila. This is cause number 328924. Case is style of state of Texas versus Roberto Davila. We have present Mr. Davila. Mr. Davila, is that your full name?
Yeah, Roberto Davila.
Okay. Mr. Davila, how are you doing?
Pretty good, John. How about yourself?
I'm doing fine. Thanks for asking. Mr. Davila, the last time you was here, I think it was January 11th, your case was reset for you to hire an attorney. Have you hired your attorney?
Sure. I had a little inconvenience about a couple weeks ago, and I don't know what happened back home. I was gonna hire someone from back home, and they just stopped reaching out to me. Well, I reached out to them, but they just no answer no more. So
Okay, so now you have 3 options in regards to you getting an attorney. Number 1, you can hire an attorney. Or number 2, if you cannot afford to hire an attorney, you can apply for a court-appointed attorney. Or number 3, you can represent yourself. You can waive your right to have an attorney and represent yourself. And I think the last time you was here, we went over the judge's explanation of rights to defendants without an attorney. Do you remember that? Let's go through give me the paperwork. You know, make a copy. Make 2 copies. We're gonna give you a copy of the paperwork. Mr. Porter, you can go over here and give him, no, he's gonna get the copy for you. You give me one and give him one. Okay. Now, Mr. Davila, just been handed a document that's titled Judge's Explanation of Rights to Defendants Without an Attorney. See that document?
yes, sir.
And is that your signature at the bottom
Yes, sir.
of that page? And or those are your initials on a line stating that you want to apply for a court-appointed attorney?
Yes, sir.
Now, if you want to change your mind, or if you still want your case to be reset to hire an attorney, you can do that. Or if you want to change your mind, and you said, wait. This says I want to apply for court-appointed attorney. Why did he?
He has 2.
Oh yes. Well, give me the latest one.
He wanted on the same same day, he has one that says he want to reset to hire his own, then he changed his mind to this one.
Well, he must have changed from this one to that one. Okay, so that was the first one. So at one time you wanted to see if you wanted to see if you qualify for court appointed attorney? Is
Yeah,
that, which one went first?
At one point, but it didn't allow me because of.
Your income?
Yeah, the income.
Oh, that's what
Yeah,
happened.
so it made me do another one.
Oh, okay, I understand. So what we're gonna do,
And I'm sorry, I think this one's that first one I did,
The
the one I have.
the first one you did, okay,
Yeah.
okay. So you did, the second one would have, you want to reset your case to hire an attorney, is that
Yes,
correct?
sir.
Let me ask you this here. Do you still need, well, how much time do you need to hire an attorney?
I'm not sure, to be honest. I'm not sure who's willing to cooperate with me back home.
You say
And out here,
you're
I
not
don't-
sure who's willing to cooperate with
Yeah, I
you.
don't know.
What do you mean by that?
Well, it's because I've reached out to a couple of people from back home. that-
Now,
that-
a parent, are you working?
Excuse me?
Are you working?
Yeah, I work.
Okay, and I think you probably filled out a affidavit of indigence. Is that on there? And based on what was in the affidavit of indigence, you didn't qualify for the appointment of a court appointed attorney. So my question to you is, why did you need somebody back home to assist you?
I don't know, so that they can help me out with this case, I guess.
You saying help you out with the case? We're just trying to find out whether or not. Because this is about what, $30,000 a year? Yeah. Yeah. Well, that's what I added up to. Yeah, and you have about 15 of that after you do all the expenses, something like that. So is it just, you don't want to use your money to hire an attorney? Or what?
It's not that, it's just that, like I said, a couple of weeks ago, I had someone that I thought was gonna help me out. And they just like stopped reaching out.
Okay,
to me.
okay, let me do this here. Let me ask you this question. Have you talked to an attorney?
So far, recently, no, it was probably about a good couple of weeks ago since I last talked to an attorney.
So you have talked to an
Yeah.
attorney?
But recent as a week, 2 weeks, no. But it's-
No, I'm not saying, I'm just saying that my question was, have you
Yeah.
talked to an attorney regarding your
Generally, yeah.
case? Now, you can,
Your Honor, I would know that he's from Rio Grande City. I'm
Yeah,
not
I'm
sure
not,
where that
I'm not
is.
from around here. That's South Texas.
oh,
Yeah,
so
so
you
we-
talking to lawyers out there?
Yeah, that's what I mean.
Oh.
So, back home. Yeah,
Oh,
because I'm only out here working. I'm not from around
so you work here?
here. Yeah, I'm not a local.
Okay. Any particular reason why you're not trying to talk to a local attorney?
I don't know. I'm not trying to get overcharged or anything. It's just.
I mean, you can talk to them and see what they charge you. I mean,
Like, I know I had, what's his name?
well, no, there are
Yeah,
several
I
attorneys.
don't remember his name, but I know I had him appointed to me, and after a while, I met up with
You
him.
had somebody appointed to
Yeah,
you.
I had someone court appointed to me,
Nathan Reynolds appointed to him.
him, yeah, and then.
Were you in jail?
Mhm.
Yeah,
Oh, I was on a jail run.
yeah, and then.
Right.
I met up with him a couple, like 2 times, and after that, I just didn't get any calls back. But this was a while back, and then when I came in for, that I wanted to look for someone, I talked to someone from back home, but they stopped reaching out to me.
Yeah, I mean, I don't know how
Your Honor,
far,
of course, he always has the option of talking to the state on his own, if that's what he wanted to do.
right, yeah, I mean, that's in the paperwork. He didn't choose that option.
Yes, Your Honor, yes, Your Honor.
So what we're gonna do, we're gonna reset your case to give you more time to get the lawyer that you wanna get,
Okay,
okay?
yes, sir.
All right. So let's give him, let's give him a 60-day reset.
May 27th.
Okay, so you're gonna stand on X. Once you get your reset, you'll be free to go and you'll be free to go and you have a blessed day. Yeah, stand on the X, you're gonna have to sign for your reset.
She said May 21st.
What was that? May 27th.
Yes, sir. Okay. No, sir, we can have this.
Yeah, it's part of bond condition. It is a judge.
Lashita Marshall? Is there Lashita Lucille Marshall? Oh, never mind. That's Judge, that's Charles McIntosh, who is not available.
He's on the phone. He said his Zoom connection stopped.
Okay, just hold on.
Sorry.
Okay. Okay, is it regarding the case?
Sort of my case. You just,
Which case?
oh, Antoine.
Okay, the two cases that was dismissed?
Yes, Your Honor. I just have one question. He has an anchor, monitor on him, and he wants to know,
I mean, what is it for? I mean, you'd have to get a order into us on that. Well, his bond conditions will be over, right? Was that a condition of his bond?
yeah,
Cases were dismissed.
Right.
so I need to prepare an order for you to sign.
Yeah, just prepare, prepare your order,
Okay,
your motion and order, yeah.
okay, thank you.
Who else do we have? Okay. Rashid Carter. Is that an MTRP? Yeah. Is his motion in here? I don't see it. Yeah, I don't see it. We're gonna need one on the next one to Mr. Howard. The court is in session and calls number 325-454. The case is filed, the state of Texas versus Rashid Shaquille Carter. Mr. Carter, is that your full name?
Yes, sir.
How are you doing, Mr. Carter? I'm doing fine, thanks, Max. Now, Mr. Carter, I have before me a motion to revoke probation. In this motion, it alleges that you, Rashid Shaquille Carter, was tried on March 3rd of 2020 for the offense of assault family violence, and that you was found guilty and assessed punishment at a term of 180 days confinement, Jefferson County Jail, a fine of $800, and your confinement was probated for a period of 18 months. On October 23rd of 2020, the state filed a motion to revoke your probation. In this motion, there are 4 allegations. Now, Mr. Carter, if your probation is revoked, you can receive up to 180 days in the Jefferson County Jail. Mr. Carter, do you understand that?
Yes, sir.
Okay. Hand Mr. Carter, the judge's explanations. Give him the judge's explanations. I'm gonna go over this with him. Now, Mr. Carter, you have before you a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. And it reads, As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option? Number three, you may represent yourself. Do you understand that option? If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Do you understand that? Now, at the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If your choice is, or if you have already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, you will sign the document where it says defendant, and you will date it today's date, March 11th of 2022. Do you understand? Okay. You could go ahead on and initial your choice and then sign and date that document. Okay. We need to give him an affidavit of indigency. Is there one up there?
Yes, Your Honor.
Mr. Carter, just take that form with you and a pen, have a seat at that table, and you can fill out that document. You're gonna have to put his name and at the top, the name and the cause number. Mr. Renee Howard. You have her motion. This is cause number 329896, case of style of state of Texas versus Mr. Renee Howard. Ms. Howard, is that your full name?
It's Miss Dell.
Ms. Dale?
Mhm.
Okay. How are you doing?
I'm good, thank you.
That's good. Ms. Howard, I have before me a motion to revoke your unadjudicated probation. In this motion, it alleges that on November 19th of 2021, that the court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the offense of trespassing, which is a Class B misdemeanor. The court deferred adjudication of guilt, and the said judge placed you on unadjudicated probation for a period of 6 months. On January 28th of 2022, the state filed a motion to revoke your probation. In this motion, there are 3 allegations. Now, Ms. Howard, if your probation is revoked, you can receive up to 180 days in the county jail. Now, could you give her a judge's explanation?
Yes, Your Honor.
Ms. Howard, you have before you a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. I will go over this document with you. And it reads, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option?
I do.
Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
I do.
And number 3, you may represent yourself. Do you understand that option? If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Do you understand? At the bottom of this document, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Do you understand? Now, if you want to apply for a court-appointed attorney, you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Do you understand that? If you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign at the bottom of the document where it says defendant, and you will place your name, then you will place today's date, March 11th, on the line that says date. Okay? Do you have a pen? Okay. You can make your choice. Yes. Okay, thanks. Who do we have? May I see her phone?
Yes, Your Honor.
Thank you.
Yes, Your Honor.
Okay. She needs an affidavit of indigence. And Miss Howard, you can sit at the corner of that table, okay? And fill out that form. And once you finish, we'll call you back up. You can get this to Brilla and she can fill that information out. And Mr. Cobb, he's on the phone?
That was Mr. McIntosh, but I can call him.
Oh,
But he was saying, his Zoom kept going in and out. So
okay, so he's back on. We need, Lashida Marshall, is she,
That was somebody, I thought you said that was like another court, you found out something was wrong for sure.
no. Lashida Marshall, her attorney was on Zoom and then he got off, now he's back on.
Oh,
But she's not here. Apparently, she checked in with the bailiff. Mr. McIntosh,
Yes, Judge.
have you been in contact with Lashida Marshall?
Not today, Your Honor, no.
I just got to know, Mr. Bailiff. Was Lashida Marshall here? Well, why don't you go get Lashida Marshall? The bailiff is going to get her.
Okay, thank you, Judge.
No, he said, put your purse there. You can come up here. This is cause number 330628. The case is styled the state of Texas versus Lashida Lucille Marshall. Ms. Marshall, is that your full name?
Yes, sir.
How you doing, Ms. Marshall?
Okay.
That's good. Ms. Marshall, you're represented in this case by your attorney, Mr. Charles McIntosh, who is appearing via Zoom. Mr. McIntosh, how you doing?
I'm doing well, Your Honor. Thank you.
That's good. Mr. McIntosh, what is your announcement in Ms. Marshall's case?
I have received discovery and I have been able to look at it, but I need to be able to speak with the government again on this case, Judge. So if we could get just like a 30-day announcement docket reset, that would be great.
Okay, this case is going to be reset to April 29th.
Can we go like maybe mid-April, Judge?
Mid-April, push him up, push him. Okay, hold on. Yeah, I guess that'll be like the 14th, something like that, or 15th. You can put him on the 15th.
We can do, that's a holiday.
Oh, it is? Which one? What about the 18th?
That'll work, Judge. Thank you so much.
Okay. Okay, this is Lashida Marshall, last one on the announcement. Now, Ms. Marshall, your case is going to be reset to April 18th of 2022. You're going to stand in front of our court coordinator on the end. You're going to get your reset. And once you get your reset, you'll be free to go and you have a blessed day. And also stay in contact with your attorney and your bondsman.
Okay.
All right, stand on the 4X.
And Judge, I believe that's all that I have today.
Okay, you're free to go as well, Mr. McIntosh. Your reset will be sent to you.
Thank you, Judge. Appreciate it.
All right, you have a blessed day.
You as well.
Thank you. Mr. Cobb, are you available? Mr. Cobb, could you take your mic off of mute?
Your Honor?
Okay, yeah, Mr. Cobb, just keep your mic on, and we'll get to you in a few minutes. Just hold on.
Yes, sir. Will do.
What is the session, clause number 330262, case and style of state of Texas versus Karen or Alicia Johnson. Ms. Johnson, is that your full name? How you doing, Ms. Johnson? You doing all right? Ms. Johnson, you're represented in this case by your attorney, Mr. Bruce Cobb. Mr. Cobb, how are you doing?
I'm doing fine, Your Honor. Sorry about the delay. Had a money client. I know.
Okay, now, Mr. Cobb, you get on Zoom and you're in court, the court call your name, the court expects for you to respond. Okay?
Yes, sir. I'm sorry about that. I apologize.
If you have any other matters you need not be on Zoom.
Yes.
Now, or outside of the courtroom. Now, Mr. Cobb, what is your announcement in Ms. Johnson's case?
Your Honor, as far as I know, I have not talked to Ms. Johnson about her case. She has a felony case right now that's pending, as far as I know. And if they, I don't know what the status of that felony case is.
Okay,
So-
I see here on the docket, the felony case is set for May 4th of 2022. Now,
Yes.
Mr. Cobb, do you want this case, this case set with your felony case?
Yes, but if it's possible, I could set it out a little bit further. So
Okay.
that way, if once the felony case is disposed of, we can dispose of this case as well.
Okay. May 20th. Okay, this case is gonna be reset for May 20th of 2022. Mr. Cobb, your reset will be sent to you. And this will conclude your case. You're free to go and you have a blessed day. Hold on a minute.
Your Honor, also record while we have Mr. Cobb.
Hold on a minute.
About a different case.
Hold on a minute. Okay, well, Ms. Johnson, you can get your reset. Stand